Go bold at boldip.com.
Good afternoon, everybody, and welcome to the Bold Inventor Show. I'm your host, JD Houvener, here with Bold Patents, with a new co-host today. We got David Bosland here with me. David, good afternoon.
How's it going?
Going well, thank you. I got
You found yourself matless, and so
I know matless. He's out hunting. He's doing some. He's hunting for deer, or elk. I think it is buck.
Oh,
yeah, out in Montana. I'm not a hunter, but obviously. he does that
before, I don't consider myself a hunter either, but I get it for sure.
Yeah. So he's gone. He said he's going by himself, which had me worried. But he said he's been at it a while, and
he'll be back.
He'll be back.
Every conference.
Very good. Well, I just today I reached out. Hey, do you want to do a live with me? And you're like, let's do it. So, and we were talking about this topic today, which is we're going to get to real soon, which is inventing on the job, which is fantastic. And it kind of brings me back to my days when I was an employee at Boeing. And I was thinking about this. This came up, and I think it comes up for a lot of people. And so that'll be a great topic. You've got some experience in sort of the beyond IP, right? With privacy thought, and we'll have a lot to talk about here in just a little bit.
Right.
Before we get to that, I want to just do a brief intro. So this is a live broadcast. We're across YouTube, LinkedIn, and Facebook today. And although we're attorneys, this is just legal information. We're having fun talking about, this area of law, intellectual property, which is patents, trademarks, copyrights. And, we're not going to be offering legal advice. So that's a sure thing. So no confidential information here being shared one way or the other, but you are welcome to participate, ask questions, be a part of this discussion. Hypotheticals are great. So feel free to plug in anything if you're watching live. And if you're watching us after the fact, know that you can catch us live. We're live every Wednesday, 1:30 Pacific. Catch it, your kind of after lunch lull break, sneak out and catch us for as long as you can. Love to have you. And if you would like to take action and schedule some time with us, I'll put a link in here below. We'll do about 15, maybe more minutes on this first topic of inventing on the job. And I've got a whole host of questions, David, we're going to hopefully get to that came in this week. I feel like everybody came back from summer and they're like, okay, let's roll.
They sent the kids off to school, and now they're just following up with the thoughts they had. I think that's
so I have like 8. I don't know if we're going to get to all 8. And then I do have a Shark Tank. As always, we got a good critique on that as well. So let me do, I need to introduce you. So you're with Bosland IP, right? Am I saying that right? That's your last name?
Bosland, David Bosland.
Bosland Law. And where are you headquartered out of?
Well, that's a good question. I've spent so much time in Seattle that I absolutely consider myself to be a Seattle-based attorney.
Yeah.
Right now, if you're local enough, I'm in the San Juans, which it's an archipelago in the Pacific, or in the Puget Sound, north of Seattle. It's island life, but it's not tropical island life. But it's pretty cool. Seattle is, if I was to pick a city.
Yeah, and you and I went to law school together, so
yes,
we're not strangers. Went to Seattle University, graduated in 2014, I think it is.
Yep.
A little over 10 years ago. Very good. Wow, time flies. Is it that long ago? Yeah. What really is scary is when did I go to college, undergrad? Right? It's like, whoa.
Shut up.
Yeah. Let's move on.
On. Great idea.
So, inventing on the job, I'd love to hear from you. I shared briefly my experience as a Boeing employee. Were you ever an employee?
Oh, yeah. Yeah, actually, I've got a couple of decades of essentially technology experience, functional matters, dev management, that kind of thing. A lot of different cell phone companies, actually. There's a lot of them around here.
Yeah.
And one bank that has gone missing now, unfortunately, and a couple other places. So yeah, absolutely. I know what it's like to be not quite the master of your own efforts.
Yeah. So, and you listed a few of those. That's almost all of them technical.
Yes.
Nature.
Yeah.
And was that your role as an engineer?
So It's interesting that you mentioned that, and not to go on too much of a tangent, but I would suspect that people need to pay a little bit more attention to what they actually do at work, because as you know, patentability is far more broad, I think, than people realize. It's like, it wasn't really a thing, or, it was a process, or I improved some steps on something, or blah, blah, blah. You need to be asking yourself, well, what was the product for that? And is it protectable IP? So I think you don't really have to be that engineer who comes up with some kind of an actual mousetrap. I think there's more work going on in the IP space that needs to be protected by all of the different IP types of things, including patents. So
yes, totally.
Get advice.
And I think it's also good to know what your role is as your job description, if you will, kind of putting some bounds on that, I think it's directly applicable to this analysis that let's just get to it, I think, about who owns an invention.
Yeah.
If you're an employee and you have an invention, and it is unrelated, let's say, to what you do on a day-to-day basis, that sort of starts the inquiry. I think it's a relatively easy answer if it lines up directly with what you're doing. If you're hired as a designer, as an engineer, let's say aerospace, let's keep that as an example, and your boss has asked you to solve this problem on the trailing edge to try to get the drag reduced, and now you come up with a cool solution to add some really unique, little fittings, a different material to reduce how much flutter you're going to get in the aircraft trailing edge, and you have reduced the drag count. You're amazing, incredible. That's potentially an invention. You'd want to explore perhaps with in-house counsel, if it's a big enough company like Boeing, or if it's small, maybe outside counsel, and talk about whether or not to pursue patent protection. We'll come back to that scenario later, but that's where it's relatively easy in terms of who owns that. It's going to be owned by the employer. Okay.
Yeah.
And again, in most every case, and we can get into this, based on your employment agreement. Okay. I think it's safe to say most employers, if they've thought it through, they have a clause or clauses that will, in other words, force you, or as the employee, to, as part of the consideration for the work you're doing and the money you're getting paid, to give up any ownership rights in any inventions you make in furtherance of the job. Anything to add to that, David, in terms of that scenario one where it's directly applicable to your work?
I think that's very clear. Even absent employment contract clauses, it's a pretty easy, it's kind of a layup to say, well, you're using our machines, you were doing what you were doing at our direction, you are an employee, and it's pretty established law that the IP you produce under those circumstances, you aren't the owner of.
Right. Yes. So that is sort of this scenario one, and it's pretty open and closed. The only perhaps that I'm thinking of way out of that is if you're a non-employee contractor, and you were clear perhaps in the contract that what you're doing is going to be owned by you, right? That would have to be specified, wouldn't it? There's no sort of.
First of all, please do that. If you're going to do work for somebody else, please put that kind of at the top that says, I own anything. Right. Even if you're producing it specifically for them to use, allow them a non-exclusive, global, permanent license, whatever, but you still own it, right? So whatever the language needs to be like, get counsel to help you craft that, but please do that. Yep. The other piece of it is that we're starting to talk about works made for hire, right? As a concept. And a work made for hire, a lot of people wave their hands and go, wow, I was hired, and so it's a work made for hire. Absolutely not the case, especially in copyright law, where the Copyright Office provides these circulars that you should go look up because they're amazing. And it's there's actually a really short list of topics that are eligible to be works made for hire. Oh. Otherwise, if you produced it, it's yours, and that's the end of it, right? So there are some complexities. If you are not a direct employee, make sure you understand the circumstances and things like that. It's a 20-minute call with a knowledgeable attorney to make
Yeah.
sure you're on the right path. Don't
Yes.
don't mess around with it.
Don't mess around. Yeah. If you're a contractor and you want to make sure you have ownership on things you create for someone else, hire an attorney to make sure that contract is going to be bulletproof. That
Yep.
kind of sounds like the answer. Do not do it on your own. There is a lot of weirdness, grayness, attorneyness that I think needs to be inserted to make sure that you're going to have, the ownership that you want. And anyway, cool. Well, that's a great conversation in itself. So you kind of now let's talk about sort of an invention that is unrelated, directly related to what you do. Let's lay out. I don't know if we have a citation, but right. You almost listed off some of these analysis, right? 3 or 4 different factors, right? So I believe one of them, I'll do one, you do the next one, is are you using the employer's machines, tools, equipment, right? I believe that's one of the factors.
Right.
So even if it's an invention outside of what you do, if you're using the employee's computer, equipment, manufacturing tools, even their phone, even your laptop, so the more you use a company's employer's assets, even if it's unrelated, that would be a factor that goes toward the employer owning it.
Yeah.
What's another factor, or do you want to?
Sure. What right does the employer have to guide how you do your work? Right. Mm-hmm. You have an objective, but can the employer say you need to do it this way or you need to do it that way? As an independent contractor, it might be like, you wanted XYZ. That's what I'm going to give you. How I do it's up to me. Right. So that would be more of a contractor perspective. Whereas if the employer has the right to say how you're going to do some things, that's more like an employee. Right. So it's not always, even regardless of whether or not there's an employment contract per se, and you got hired and you get days off and all of that. If you're really rolled in underneath what they're trying to do and they can direct how you do it, that's also another really driving factor as to whether or not you're actually an employee-employer situation for the purposes of who owns IP.
Yep. Awesome. What other factor might you consider in this analysis? So we talked about the big ones, right? Is it related to the job? We talked that. Mm-hmm. And then the
equipment, office space, and then how much control they have over what you're doing. There are some other things, but they kind of move into whether or not the employer is responsible for torts and were you operating in the furtherance of the duties that your employer provided you and things like that. Those are the things that are coming to mind. But
yeah.
I saw your email this morning and it just started to make me think, well, gosh, as an employee, what control do I have as to whether or not a patent is pursued? Right. Is it, are you going to prosecute this patent or not? And then after you said, well, and I thought, gosh, what if I don't want my name? You said attribution is required.
Yeah.
Right. The company owns it, but attribution is required. What if I don't want attribution?
Interesting. Let's lay that out. So you and I had some correspondence. Let me just lay the foundation. So the question is, if you're on the job and there's a potentially patentable invention, as the inventor, can you pursue it, even though your employer has no intentions to pursue it? And I think the answer is yes. 99% sure. I'm very confident. I don't see why not. As an inventor, you can file it. The major downside is the employer is not going to foot the bill. You, the individual inventor, will have to pay for hiring legal counsel, paying for the filing fees to do that independently. And there may be some other layers there too, right? So very interesting here, David. I think because I may be able to backtrack my answer. Within the employment agreement, there is confidentiality. There are trade secrets.
Yeah.
And so what might be patentable could be trade secret information. Therefore, when you by you filing a patent application, even though it's a provisional, let's say, if you follow that path forward and file a non-provisional, and you don't, and you do allow it to publish, you have now potentially fallen it toward misappropriating a trade secret. I think taking steps toward that.
Yeah.
How interesting. Okay, so
Yeah.
I may actually reconsider my answer.
So I think the answer is still probably yes, but could you get in trouble for doing it? Is also probably yes.
Yeah, totally. I don't want to get bogged down too much. And then you're like, okay, well, yeah. So privacy. Let's say, as the inventor, again, this is I didn't have quite enough time since this morning to go research it. I am 99.9% sure. I'm 100% sure. The inventor must be named. A human being must be named. You may not file an anonymous patent. There's no such thing as anonymous inventor that I am aware of. So an inventor must be named, and therefore it will be published. You can wait all the way until it becomes granted. You can file a non-publication request if you want to remain right in this sort of, while it's pending. And so if you do that, you give up the ability to secure rights overseas. So this privacy question, which I think is maybe the origin of this, you really have no desire. You don't want to be named as the inventor for whatever reason. Right.
Yeah. Right. For whatever reason, like say I invented a better mousetrap, but it only catches ducks. Company loves it. I think it's retarded, and I don't want to have my name associated with it at all. And they're like, well, we have to put your name on it. It's like, please don't do that. So then
I think we should even push some hot button topics. I mean, let's say in pharmaceuticals, or maybe it's something having to do with, reproductive medicines, or where it's very controversial, right? Or maybe even, let's go Oppenheimer, right? I've developed a nuclear weapon, and I by no means want my name attached to it, but I've been told to create something. So that would be quite controversial. We're living a case where you may not want to have your name attached to something such like that. You're sort of
maybe you pulled together a really fantastic anesthetic that you thought, oh, this is going to be wonderful. Fentanyl is garbage, and this is going to be super excellent. And then the company wants to sell it to the states as part of a 3-drug execution package, and you're like, that's not me, man. But that's how they're going to sell it and market it, and your name's all over it. So yeah, that's entirely possible. Which that's what got me thinking. How much leverage as the inventor do I really have? Because what made me think of that is you said an inventor must be named. It's like, well, if there was just one person, can I halt this or come up with a different name? Because so it made me think about rights of publicity and rights of privacy, and there really isn't federal law specifically for either of those so much. There's analogs sort of in the Lanham Act for trademarks. I can't advertise a product and falsely make it look like you're associated with that product or endorse that product in some way. So that's a bit of a right of publicity, right? It's not privacy so much. It's the fact that you are you. You own your signature, your image, your likeness, your persona, all of that stuff. And this is becoming so much more important in this age of influencers. Everybody's third cousin is an influencer in some social media platform, right? I'm being silly, but it's true. People make really good money off of this, and it's important. And the thing that is of value is that publicity that you literally own. About half of the states have right of publicity laws, so protect it in some way. About half. The other half, most of them sort of protect it, but through rights of privacy. Right, the right of privacy is a little bit older. It's got Supreme Court backing. About 60 years back, Griswold v. I don't remember what, that established rights of privacy as a penumbra off of the personal rights amendments, like first, third, fourth, fifth, ninth. Those things have personal rights, and so
So
You're right.
image and likeness standards, or is that more for famous?
No, this is just, hey, you can't. I have a right to be a private individual.
Okay.
Search and seizure, things like that. I can go into my house and stay there. Nobody has a right to say, "Oh, I want to see David." It's like, nah, piss off. I'm staying here. So that's where that comes from. Whereas the right of publicity is almost like, take who I am, and I have the right to monetize that.
Yep. Okay.
Just like anything I create, it's who I am. I can monetize that. So wouldn't it be nice to have a federal law that helps us unpack that instead of this mosaic of laws? It's like,
right.
Don't get me started on the Digital Millennium Copyright Act and the fact that we don't have something like that for trademarks. But
yes, yeah, that's a whole
different
whole different topic. Yeah, well, I think we've covered this at a decent level. I want to welcome anyone out there that's watching on LinkedIn, YouTube. Fire away with any questions, clarifications. We'll stay on this for a few more minutes, then we'll jump to our other Q&A. I think to kind of wrap it up, I think I'd like to just talk about what we would say to do to the hypothetical client, how to protect an invention that you've invented. As yes, you're an employee, but you want to protect it and keep it separately. I would say to that inventor, hey, just make sure you're off the clock. Make sure you're not on the job using their equipment, tools. Make sure it's totally unrelated to what you're doing, what you're paid for, what your job description says, and make sure that there's, those are the big ones. I would say there's no control, right? There's no evidence or ability for the employer to say, hey, we directed you or asked you to do this for us. Mm-hmm. Is that about right? Is that kind of the big one?
It's pretty close, I would say. However, in reality, the time we spend during the day tends to be where we're thinking and our ideas come from and whatnot. So at some point, it becomes a slippery slope, tangential kind of thing. It's like, if I follow this thought back, work was involved somehow, right? You just want to separate yourself as much as you can from that. And so, like JD, like you were saying, it's like, don't do it at work. Go and get a secondhand used laptop and just noodle the stuff out on that, not your company laptop. And then, depending on your relationship with the people you work with or work for, like you say, some sort of freedom to operate. It's like, I have this other thing that I'm working on separately, has nothing to do with work. And if you can get something that says, knock yourself out, I mean, that's probably the best.
Yeah. At Boeing, I decided to do one, even though it was very unrelated to my work as an engineer. I did what's called a conflicts of interest form, or get a waiver. Hey, I'm going to start up a separate entity, separate business for my law firm. Obviously, I have no intentions. It doesn't seem to, or does not conflict with my work. Here's what I'm doing. And I would say 99 out of 100 times, they're going to say, yep, looks great, thumbs up. So being above board, honest, hey, I've developed this product totally separately on my own. I have plans to commercialize this separately. Does that sound good? Right?
And you brought up trade secret, and a trade secret only just in the last few years became a federally supportable law. That was all done by the states and whatnot. And now that employment contracts are limiting, the employment contracts can't so much say you can't go work for company X, or you agree to spend 3 years not doing your job after you leave us, kind of nonsense. So the companies can't restrict how their intellectual property leaves the company by keeping people from working.
Correct. Right. Yeah. Non-competes are on the way out.
Trade secret law and how that's handled is becoming more and more important. So what that means is that for you also can't just wait 3 years and then go nuts.
Yeah.
You really have to understand what your obligation is to any sort of previous employer with respect to their intellectual property, or what might be their intellectual property. Like you were saying, they decided not to get a patent. They're just going to go the trade secret route, right? And we'll keep it forever. We don't think it's reverse engineerable, Right. So why would we do a patent? So
I think
it's another 20, 30-minute conversation with an attorney that could save you so much.
Yes. Yeah, I think it's in this age where we're getting more and more data, right? Whether to collect it, to make all these LLMs, for all the AIs, you have to be even more on purpose about very clearly documenting this is where we're keeping this very special information. We're only giving it to a very small amount of employees, and this is how we're going to deal with it when you come and when you exit. So all that just takes all the additional hoops that will help you with enforcing a case for misappropriation.
Yeah, I'd throw out, this is more for employers than employees, but I'd throw out a plug for Tangibly. There are Tangibly, yeah.
Okay. Yeah.
Go to tangibly.com. They just do a wonderful job with this interface between patenting and trade secret. And then once you got these, what are your trade secrets? Number one, who knows what they are? Number two, right? I got to work with a contractor, so that person's got to be NDA'd and all of these different things, right? So like you were pointing out, you really, as an employer or any sort of an entity, you've got to be very deliberate about keeping track of these things, because that deliberation is what will come into court later when you're trying to show that somebody misappropriated your IP.
Totally. All right, David, we have, I think, answered that question. How do we invent on the job?
Whoa, we answered a question. Fantastic.
We answered a question. Let's jump to our more rapid fire, kind of, 3 to 5 minute answer Q&A session.
Yeah.
I'm going to do a quick type here. I welcome any live questions. We will prioritize you. Let's do it. So I'll tackle some patent stuff. I'll give you everything else. In fact, you can chime in on the patent stuff too, if you'd like. We have a host of questions from Quora and Reddit. Amira did an amazing job getting this. Let's see. I'll find one. Okay. This is patents related to provisional patent unexpected costs. Uh-oh. Here we go. Let's see how much of this comes through. Okay. Hi, everyone. I handed in a provisional patent application, for which I paid the $60, which was required to file at the USPTO. 2 weeks later, I got a note from the USPTO with a notice to file missing parts of a provisional application. And it says I need to pay an additional $300. Ouch. So apparently the $60 counts as a surcharge for late submission. If anyone knows if this is correct or has an explanation, much be appreciated. Okay. Well, and so, being right up front, I haven't filed an application in a while myself. We have a paralegal team that does that. I will say the notice is usually pretty clear in terms of what is missing, hopefully. Usually when you submit an application for a provisional patent application, it is far less rigorous than a non-provisional. A provisional must have a specification and a cover sheet. And then I think a fee. David, I don't know if you have anything else. It's not much. And figures as needed. They're not required. Usually it's a good idea. So the specification is a fancy word for written description of your invention. And, the goal there with the provisional even is to make sure that your invention is fully enabled. So you want to make sure it's written not just high level, but really laid out so that someone could go make it and use it. A lot of inventors make that problem, I should say, when filing on their own, is they're just not as detailed. And they usually don't cover a lot of applications or versions or other embodiments of what their invention could look like. So it's really just kind of this one narrow invention of what they've built, perhaps, or what they see as going to market. And really, a proper provisional should be very fleshed out, covered in a lot of different aspects. Without going too much further on that angle, I think that's it. It's a spec, drawings, and a cover sheet with payment. So, David, do you have anything else you might?
Just a practical bit, which is as soon as you've put something into the USPTO and your contact information is on it, you will be contacted. Not necessarily by the USPTO and not necessarily by people who care if you know that they are or not. So it's the ones that look really real are the ones that we need to be the most concerned about. The ones that are clearly phishing or spear phishing or whatever you want to say. Right. Those are easy to sidestep. Not a problem, right? It was drawn in crayon. I'm just saying you're just because it looks like it came from the USPTO, do what you can to make sure that that's a legit communication.
Yes.
When somebody's saying, "Oh, you need to give us $300 more," actually, the USPTO usually says what you've done is insufficient. Bam.
Yeah.
They're not going to tell you what to do about it. So I get suspicious immediately when it says, hey, just pay us another $300 and you're good to go.
I agree.
Really?
That's a great point. There's a lot of fraud. I see it. Matt mentions it more on the trademark side.
It's constant.
Gosh, it's just awful. The Bureau of Trademarks, right? No, there's just one. Make sure it's a government entity. I believe these marketing companies, they're required to have a statement that says we're not affiliated with a government institution. You got to read the fine print. Gosh, they look official. They all kinds of QR code scanners. You've got to read through it. One great way to avoid all that is just hiring counsel and just get it done right.
Yeah.
All right, let's jump to our next question here. Thank you for that question. This is on the trademark side, and I will read it off for our future podcast listeners. I run a marketing agency and would like to trademark my own company name. Plus, I have a client looking to file a few trademarks or the intent to use. I don't think any of the desired trademarks will be particularly complicated. One also includes a logo. Would love suggestions on attorneys or firms in California. Prefer something smaller, more personal than the big firms. Hey, I do know a firm. There's a couple of good firms here on this show.
I can think of two.
Yeah. Any thoughts on
that? Yeah, I'll start by just saying, my trademark professor is not dead, but if he was, he'd be rolling over in his grave he's like, trademark is not a verb, but we use it that way all the time. So we don't trademark something. I will say immediately that trademark rights come from use. Trademark rights stem from use. The first step is using it as a trademark. If you're not sure what using it as a trademark means, putting it on your t-shirt right here is ornamental use, not a trademark. It's on the collar, or it's on the hang tag, or it's on the invoice, or the top of a menu, that kind of thing, or over a storefront. Remember back when we had bricks and mortar?
Yeah.
All of that's trademark use, and you need to have that, right? And they mentioned intent to use, which is cool. You get 6 months plus extensions up to 3 years as an intent to use application, so that you're not actually using it in commerce. But ultimately, if you're going to have a registration, it's got to be backed up by using that trademark. So get out there and use it. Other than that, the very first step is not registration, not even close. The first step is a search. And you'll hear people talk about a knockout search, which is great. That's the next step past doing your own Google searches or Yahoo or Bing, or whatever you use, which is also a good place to start. But what you'd really like to have ultimately, because of the value that a trademark is, and we can have a whole nother thing about that, but the trademark is so important. Don't spend any money on it. Don't get a vinyl wrap for your delivery van. Nothing. Don't do anything. Don't spend a dime until you know the trademark you're proposing is one you get to keep. So what you really want is a proper competitive analysis of the mark that you're proposing, right? Yep. Who else is using it? Who else is using something similar to it? Who else is selling snow tires, even though you're just selling, I don't know, replacement horns for bicycles? They might be related.
Yeah.
So, you need to understand what the competitive landscape is for the mark that you're proposing. So start with a search, and you need to have that use, because without the use, the registrations won't perfect, and they're assailable anyway. So
beautiful. All right. Excellent, David. Thank you. Let's jump to another patent question. This one came in. I do see Jonathan's out there. Jonathan, good to see you. He asked a couple of good questions last week. Feel free to jump in if you have any questions or follow up there, Jonathan. I have an idea for a very profitable and amazing invention. This would, I think, permanently replace all light truck bed covers and possibly an application for sedans and SUVs. But I have no clue as to where to start. I'll say that I made rough sketches of my idea, but all in all, I'm very green when it comes to building a prototype and drawing sketches. I want to submit a patent, but have no idea what to do, how to get there. Any help would be much appreciated. Okay, well, I love it. Truck bed cover. I've been a truck owner, no longer a truck owner, but truck bed covers. I think they're kind of talking about a canopy or just any type of a cover on it. Can be quite important, especially if you run out of room in the cabin. You want to be able to store something and not have it get all wet. What I will say here is, to get started, one concept is, and this may be a sort of just a clarification. They mentioned prototyping. You don't have to actually ever prototype or build in real life your invention to get a patent on it. You've just got to be able to lay it out with words and drawings and convince the examiner with that it's been, it's novel, non-obvious, and has utility. So sometimes there is, and it makes a lot of sense, and a lot of cases to go build it out, make sure that it is and works the way you think it does. But if you're truly, concerned about the cost, or maybe the other side where you're certain it's going to work, and you want to just move forward and file the thing without having to, build it first, you don't have to, right? There's no more need to submit the actual invention. I think the only times they'll do that is if you're claiming a perpetual motion machine. They'll say, "Bring it in,
bring it on in."
Yep, love to see it.
A model of what you were going to patent used to be required way back,
right?
Yeah. So that used to be a thing, but it's not a thing anymore. My other thoughts, because he was asking about prototyping. Sometimes prototyping is about finding out whether or not your idea is actually something you want to move forward with. And not all patent applications are intended to move forward with, right? How many times has a company got a patent almost specifically so that they could sit on it? They own it. They don't want it in the market. It's the disposable razor problem that you may remember, right? It's like, I don't remember what company it was, but they made proper old school razors. And then disposable razors started to come out and cut into those sales, right? So the idea was, well, we'll get a patent for a proper disposable razor, and we simply won't make it.
Got it.
Because it cuts into the sales of our existing product. So sometimes you need to know, you need to do the due diligence to find out that, because you want to build it, right? So you want to know that it works. So you're going to do some prototyping and da da da. As soon as I hear prototyping and da da, all of that stuff, my first thought is shut up, stop talking, don't talk to anybody. Period. I mean, it's the first piece of advice I give anybody is check out the statutes of limitations and don't talk to anybody. Those two things, right? And that's where you need to have the right kind of NDAs and things like that. These are the sensitive bits, and those things have to be in place before you start talking to somebody who does have the skill set to produce the trial products, so that you can evaluate them, do that prototyping.
Yeah,
that's not really an answer to the question, though. It's like, where do you start, right? But
I think it is. I think it is. Yeah.
Simply don't start until you know that you're not offering up your idea and starting that 1-year clock, right?
Huge points. Yeah, I think this was a simple question. I think it's got really cool. We have a lot of different angles we could answer this. Trying to be simple is prototyping it, building it is very useful. If you as an inventor need to prove it to yourself that the thing works.
Right.
Or that's huge. So if you can do it on your own, that's best. If you need to go to a third party to bring it about, make sure you have a very nice attorney-approved contract with a non-disclosure agreement to make sure that whoever or what company you're hiring to build it will keep it confidential. Because like you said, you do not want to start that 1-year clock, which is, hey, as soon as it's in the public or as soon as it's being sold, now you have 1 year to file it. And then the next thing is, while you're going through that process, make sure that it's, there's a sizable market. Okay. The biggest point about getting a patent is you want to make money. And so if you're going to be, going after something and it's such a small little niche, area of the market, you don't see you're going to be able to recoup your investments. You don't need a patent, right? You can go kind of have this hobby or, kind of a smaller vision in terms of what your sales will look like. What are your goals? Kind of that, right? But the other side is that once you do convince yourself that you want to proceed with the patent, like David, you mentioned on the trademark side, do some diligence first. You want to make sure you do a thorough patent search to go see if, even though you think it's great and it's awesome and you can build it, Has anyone else done it before? Or is it so close to something else that's been done before that it's not going to be worth going through filing?
Yeah. And a lot of your opportunities, China is actually getting easier to work with, not harder, but the regular NDAs that we might use here might not work there. The same document in China is called an NNN, so non-disclosure, non-compete, non-circumvent. So there's this concept. I didn't do it, but my uncle did because I circumvented it. Right? So they just have to have additional language, and then you have to respect that those are just. It's just a different jurisdiction, right? I was saying that trademark rights come from use. That's not true in China. So if a trademark is involved and you're starting to engage with China, then one of the first things you might do is go and file for your trademark in China, right? So it's another reason to make sure that you work with somebody who at least knows what to be worried about.
Yeah, issue spotting. Yeah, exactly.
Right.
Very good, very good. Let's do one more. This one is a relatively straightforward question, but could go a lot of different directions. And then we'll jump to our bold bite where we critique a Shark Tank pitch. This one is on the other side. After you've gotten the rights, how, in terms of infringement, let's say you're trying to avoid infringement. This question is, how much differentiation is needed to avoid patent infringement? And I will say patent rights are governed by what's written in the claims. For a utility patent, it's what the extent and the scope of the written claims. On the design side, it's what's in solid black line. What's shown in that drawing is a three-dimensional article. What you've got to do, let's say on the utility side, to avoid infringement, hire an attorney to help you. Okay, but read the claims. If you're able to discern, what an attorney would advise you to do is they'd read through the claims, looking at the broadest claims possible, which are usually the independent claims, and break it out element by element. And so long as you are not meeting one of those elements, you're not infringing. And so that kind of goes to say the more detailed a claim in general, the more specific it is, and the easier it is to avoid infringement. Anything else to add to that, David?
Just starts me thinking about how you're drafting them in the first place with those sorts of strategies in mind, right? We keep talking about, well, there's a lot of this stuff we can do by ourselves, right? As individual inventors or business owners trying to protect their trademarks. Absolutely. There's so much of this that you can do yourself. And JD, you and I can sit here and answer question after question after question and answer all of this stuff. We'll give away all of this information and knowledge. There's no way we can take anybody to law school. It's just not going to happen, right? So the like you mentioned before, the issue spotting, but also partnering with somebody to get strategic about what you're trying to do. How should we draft these things? It's like the same thing in trademarks. Like, what is the description of the goods and services that I'm providing? And how do, as I add more, it gets more specific. It can. And then it's maybe that much easier for somebody who might be using something confusingly similar to say, yeah, but mine's enough different. I'm enough different that it's a different market. It's a different reasonable purchaser. That relevant purchasing public is a different group, or it's in a different channel, or these kinds of things to try and avoid that infringement. So you don't really want to open too many doors for folks.
Totally.
You can avoid that.
Yes.
But sometimes you have to get pretty specific and narrow because you're trying to thread the needle between this cool patent and that cool patent. It's like, no, my stuff's right here. It's right here. So sometimes you kind of boxed in, and that's you really do have to get specific, and that's what you need to do. And again, that's the guidance part.
Yeah, totally. The strategy, you nailed it. Yeah, it's not just that question. Your goal is to avoid being sued to begin with, right? You don't want to have to go through, even if you're right on the merits. You don't want to be so close, if you can, that it would even come up. So there's a lot of different scenarios and the practical advice that you can get when you hire an attorney that's used to looking at this sort of stuff. All right, David, we've made it to the end here. We're going to talk about, we're going to critique a Shark Tank pitch. I'm going to put up on our screen here. If you'd be so kind as to go on mute until we're done showing that. I'm going to share a screen and we'll look at this clip from a Shark Tank pitch. Not sure if you're a coffee drinker, but this is related to coffee. And so Cold Brew, the name of the company is Brew. It was presented to the Sharks in 2018, I believe. It's got a cool young entrepreneur pitching.
Next into the tank is a cost-effective way to make a trendy beverage at home.
Hi, Sharks. My name is Max Fieber. I'm from Detroit, Michigan, and I'm seeking $50,000 for 25% of my company, Brew. I've perfected a new way to make cold brew coffee at home without the need for complicated or overpriced equipment. When I was just 15 years old, I fell in love with coffee. I tried making it. 15. I tried making it, roasting it. I did everything I could to learn more about it. One day, I stumbled across cold brew coffee, and I was dying to try it. If you're not familiar with cold brew, it's a type of coffee that's made in cold water instead of hot water. This doesn't extract the acidity out of the coffee bean, so it's smoother, it's sweeter, and some even find that it's easier on their stomachs. After watching countless videos online, I found that people use mason jars to make it themselves at home all the time. So that's what I tried. I took ground coffee and cold water and I put it in a jar to let it sit in my fridge for 24 hours. Then I tried to filter it. I used a cheesecloth, a pour-over, paper towels. It just went everywhere. I made this whole mess all over my counter. My parents were mad. I didn't have my coffee, and I wasn't about to spend hundreds of dollars on a complicated cold brew coffee maker. I knew there had to be a better way. So I ran into my garage, I ripped the screen door off the wall, I grabbed a hot glue gun, some mason jar lids, and after some trial and error, the first prototype of Brew was born. Obviously, we've come a long way since then. So let me show you how it works. First, you take some ground coffee and cold water, and you combine it in a standard mason jar. So I'm just going to fill it all the way to the top with the water, and there's just a little bit of coffee at the bottom. It's really all you need. Now I'm going to put it in my fridge to let it sit overnight. It's really fast. Wow. So now you take the double-sided brew filter, and you insert it straw side down into the mason jar with coffee. Then you take an empty jar and you secure it to the top.
Oh.
Now, just flip and watch as your coffee drips in the top jar, through the filter, into the bottom jar, giving you some delicious cold brew coffee. This any wide mouth mason jar, you can find it at practically any grocery store.
What's it cost you to make it?
It costs us right now $4 to make it in that package. And with scale, that's going to drop to $1.50 with a new 2-cavity mold. So we're selling it online right now. Big box retail is what we're aiming for in the next year.
Where would you want to be in a big box retail store?
So this product would do very well in, something like a Bed Bath & Beyond or a Target.
Do you have competition?
There are other cold brew coffee makers. They range anywhere between $50 and $250.
And what do they do?
So there's one that you put on your counter and you add it, it's this big and you put it on your counter and it sits and there's a valve at the bottom and filter it. There's really nothing that's designed for somebody using a mason jar that just wants to do it the same way.
I get the sense that you're running at about 115% and drinking a lot of the product. I'm not kidding.
Thank you.
I like the higher margin. So are you open to focusing on the higher margin as opposed to pushing the price down? Because instead of spending the money on the new molds, you can push that into advertising.
I hear that.
Okay.
Yeah.
I'll give you the 50K for 30%, and I want to know now.
Yes.
All right. Deal. Mark Cuban was the shark there. You got 30%, huge chunk of the company, young guy, 18-year-old. Seemed like he had his act together. What are your initial thoughts on that product and presentation?
Yeah. I did turn my mute button off, right? Still here. Fantastic.
Yep, you're good.
All right. Technical success. Yeah, I loved the sort of the physics of it, the simplicity of it. He's absolutely right. Mason jars are everywhere. I must have a dozen of them myself. I'm not sure why, mostly just for pickled onions and whatnot. But, where you take something I don't have a whole lot of space. I really don't have a whole lot of space. So something simple like that, where it's just like you put it together, you stick it in the fridge, you put the top one on, flip it over, clean out the grounds and repeat as necessary. Speeds things up. I think it's excellent. I think it's a great idea. Then my challenge then becomes, how do I keep other people from going, oh, that's easy enough. And he's got a metal one. I'm going to make a plastic one, or, I'm going to make one that's got the Cincinnati Bengals logo on it, or, somebody's going to come along and kind of steal his thunder a little bit. I think would be my concern.
Well, and so one thing you can do is you can get a patent. He did. Max Weber got his patent issued. 9,993,011 back in 2018. This is a utility patent, and looks like a firm, Arnestaki and Pierce, and it looks a lot like what he showed on the Shark Tank with some of the figures. And I'm not going to read through the whole patent, but one thing I mentioned before, it's not the pictures that you own. It's a set of written claims at the bottom. So this is all part of the specification for those that are unfamiliar, describing what the invention is, maybe the method as well. And so he's got an assembly. So it's a physical parts, and you can see each of these paragraphs make up each element of that. And this is what's called the preamble. So it doesn't have a whole lot of bearing in terms of the scope of rights, but it's got to have a first side, a first coupling, a second side, a filter between the two, supporting member with an air channel, seems a little bit specific there, and then a tube. Tube is fairly specific structurally, but it is, obviously it's cylindrical in nature and has to be connected to the support member from the first side and the second side. So there is some language here. They likely had to overcome some office actions, but it's basically a double filter. And so I think this is in general a pretty good thing to have. This would protect you from someone copying it and just changing materials, right? A utility patent protects the functionality so long as each of these elements are found in any infringing article. So they did get that. That's one way to do it, right?
Sure. Well, yeah. And I know it's the way we use the language, I think, needs to change a little bit, because the same thing happens in trademarks. It's like the registration or the patent or the copyright or whatever protects you. No, it gives you the right to protect yourself.
True.
This is maybe a little bit of a tangent, but I just want people to recognize that pursuing these things just puts the legal details around the thing that you have, the invention that you have, the photo that you took, the story you wrote, the cool logo you created, whatever. And it just says, it just establishes that as a legitimate thing. Then you have the opportunity to go and protect yourself with those things, right? So monitoring, making sure somebody else isn't doing it, pursuing them if they do, that's all still you. The federal government's not going to do that. Like I tell people, there's no trademark police.
Yeah.
With one exception, but it gives us the right to protect ourselves. All of this stuff does.
Absolutely. Yeah. They did, just a quick update, they did so Mark did the deal. They did move forward with that investment. They made sales in 2018, 2019, and he sold the whole company to a company called Snarky Tea. If you've heard of Snarky Tea. It's also, interestingly enough, a Shark Tank company. Mr. Wonderful invested in Snarky Tea. I'll show it off. And then at least on perusing this site, I didn't see the specific double mason jar product for sale. But hey, at one point in 2020, at least on this the Shark Tank update that I was reading, they did make a sale. He made an exit, which is a win.
And so it kind of brought it up before. It's entirely possible that Snarky Tea said that is going to cut heavily into some of the things that we produce. They bought it off of him, and they're never going to make it. Right
there, you go. In a defensive strategy, right?
Yeah,
acquiring patent portfolio to prevent
which could be a really good deal for both parties.
Yeah, that's a great point.
The kid makes a great start. and Snarky T owns something that now can't compete, for the duration of the patent,
Right.
with the other things that they make that might not read on the patent.
Yeah.
They own it and they can just sit on it.
Yes. Awesome. Well, very good. Well, we didn't get any live questions, but I think we definitely covered a lot of ground today. I want to thank you, David, for being with me here today on our show. And we'll potentially have you next week if you're open to it. Matt is out as well. So you'll be kind of our fill-in.
Yeah, sure. Always a pleasure.
Are you okay if anybody listened to you and they liked what you were saying, if they get a hold of you via email? Is that all right if I share that?
Yeah, it's not a problem.
Okay.
Not a problem.
I will share that on the notes here. Actually, if you could just give that to me, I'll put that in right here.
Yeah, it's super easy. David at Bosland.law.
Oh, you got that cool .law. That is very nice.
It's a vetted top level domain, actually, which is kind of cool.
Vetted. What does that mean?
You have to show evidence that you're an attorney or a law firm to get the .law.
Okay, I'll make a quick note.
Yeah.
or Bold if that's out there. Awesome. Well, again, thank you, David, and for Bold Patents and for Bosland Law. Wish you guys a great week. Hopefully see you next week. Thank you all for joining. Go big, go bold.
Go big, go bold at boldip.com.